Good morning, Mr. Kennedy. Good morning, everybody.
Good morning, Chair.
Are we ready?
We are, thank you, Chair. And the next witness, the only witness scheduled for today, Chair, is in the witness box and is ready as well. May we then proceed and ask you, Chair, please, to grant us leave to call as the next witness Mr. Reenen Teubes.
Yes.
For the record, his surname is spelled T-E-U-B-E-S.
Thank you. Thank you. Please administer the oath or affirmation.
Please state your full names for the record.
Frans Reenen Teubes.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth and nothing else but the truth?
Yes,
If
I do.
so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated, Mr. Teubes.
Thank you. Can you switch on your microphone, please? Just push the button. Thank you. Good morning, Mr. Teubes.
Good morning.
You're currently employed where?
I'm employed at Denel Land Systems.
That everybody refers to as DLS. Is
That's
that
correct. That's correct.
And what's your current job title?
My current job title is General Manager, Combat Systems.
Now, is it correct that you've cooperated with the Commission, its investigators and legal team, and have provided a number of affidavits to us?
That's correct.
All right, thank you. Chair, may we refer you to the bundle in which you will find the two affidavits that will be referred to. It is in Denel Bundle 05.
Yes.
And it's
So the bundle we'll use today is Denel Bundle 05.
It contains only one exhibit, which is W17. May I ask you, please, Mr. Teubes, to look at a particular page number? If you can just bear in mind, there are a number of page numbers that appear written or typed in at various spots on each page. I'm simply going to refer you to the top left-hand side of the page. Can you please open where it says Denel-05-006 on the top left?
Looks like the aircon is quite noisy this morning.
It is, Chair. Someone can sort it.
The person who normally attends to it doesn't seem to be around. Okay, all right, let's continue.
Thank you. Do you have that page number?
I do.
And for convenience, I'm just going to refer to a page like this just as 6, not give you the full number, okay?
Thank you.
All right, thank you. Am I correct in saying that this is the first page of
Just
your...
1 second, Mr. Kennedy. I don't know if it's going to be too hot if it's switched off completely. So explore the possibility of not switching it off completely, but maybe it shouldn't be such that it makes as much noise as it has been making. Okay, all right. Somebody is attending to it. We can continue.
Thank you, Chair. It does become very hot as the day progresses here.
Yes, so it's important that you should let me know, because I might not know how hot it is that side.
Yeah.
But at least I think that level of noise is better than before.
It
Okay.
provides better audio, and it provides also some relief from the heat.
Yes, okay.
It seems to be a good compromise. Thank you
Yeah.
very much.
We
Mr. Teubes,
thank this technician.
yeah, multitasking technician,
Multitasking.
and registrar.
Yes,
Mr.
okay.
Teubes, this is the first page of the first affidavit that you provided to us at the Commission. Is that right?
That's correct.
Is that your name on page 6? And can I ask you to turn, please, to page 50.
I've got it, Chair.
Is that your name and signature that appears at the foot of the page?
That's correct, Chair.
And if you turn to page 51, are those the details and signature of a commissioner of oaths in front of whom you took the oath to confirm the contents of this affidavit?
That's correct, Chair.
Right. Have you been through this affidavit, and are you satisfied that the contents are true and correct as far as your knowledge goes?
That's correct. Yes, thank you, Chair.
Chair, may I just refer you to one tiny technical problem that has arisen? If I can take you to page 10.
Yes.
You will see at the foot of the page where the person typing the document has inserted the typed page number. It's page 5 of 46.
Yes.
And then if you turn the page, it jumps to page 7 of 46 at the bottom. And then the following page, which is at page 12 of our bundle, it goes back to 6. So all the pages are here, but the sequence, I'm afraid, has been mixed up.
But
And
is it only in regard to these 2 pages where page 7 appears and page 6 appears?
As far as I'm aware, that's the only glitch in this affidavit. I just
Okay.
wanted to point it out up front
Yes.
because when I first started looking at the affidavit,
Yeah.
it's jarred.
One could spend time trying to find.
Indeed.
Yeah, yeah,
So if I can just have that placed on record.
yes.
And then, may I then ask, we'll deal with, there's a supplementary affidavit later in the bundle, but we'll deal with that separately if we may.
Yes.
Chair, may I then formally move for your leave to admit this affidavit in Denel Bundle 05 from page 6, including all of its annexures. I would ask, Chair, for leave to have that admitted as part of witness exhibit W17.
The statement stroke affidavit of Mr. Reenen Teubes, starting at page 6, together with its annexures, is admitted as exhibit W17.
Thank you, Chair. Now may I ask you in the same bundle, please, Mr. Teubes, to turn ahead to page 850.
I've got it, Mr. Chair.
850.
Yes, Chair.
I
Should be
don't
right
seem-
at the end.
I seem to go only up to 849.
Then I'm afraid there's a,
Yeah, I
Yes.
go only up to, mine goes only up to 849.
then there is a problem. This was added to our bundle only yesterday by the Secretariat.
Yeah.
It seems that, may I
Is
just
it one of
ask-
the pages you handed up at some stage?
I'm sorry,
Luz?
Chair?
Is it what, is the missing page, one of the pages you handed up yesterday? Because there is a page that I think you handed up, a document, one page, I think, which would have had to be put in, but I don't know if they didn't put it in.
Yes, I don't know. I hope that that has been done. But that was for a different witness. But Chair,
yeah.
this will be a problem. I will take a bit of time to deal with the main affidavit. The supplementary affidavit that is not in your file needs to be put in. May we just ask through my learned colleagues that steps be taken for the appropriate staff in the Secretariat to make sure that a copy is made available
Yes.
to us to hand up when we're dealing with it.
Yes, okay, no, that's fine.
Thank
That's
you. Perhaps I should wait for that to arrive for you to see it so that
Yes.
you can be satisfied before you admit it
Okay, no,
as,
that's fine,
as evidence.
that's fine.
Thank you, Chair. May we just indicate that last night from the attorneys who've been assisting Mr. Teubes, provided by Denel, as Mr. Pillay and Ms. Wilsnach, Mr. Pillay is present, I'm not sure if Ms. Wilsnach is here.
Oh, yes, yes,
But
yes.
they sent us yesterday evening a further supplementary affidavit in draft form of Mr. Teubes. I've had a chance to go through that. It's very brief. And as Mr. Teubes has pointed out to me this morning, It's not meant to change any evidence. It's just to provide a little more detail and some sequence.
Okay.
If we can leave that to deal with that at a later stage as well.
Yes, no, that's
Thank
fine.
you.
But going back to whatever document I don't have for page 850, if one of your juniors has got one that they are using, maybe they could borrow me that one
Yes.
so that you can continue on the way you had planned to in terms of asking the witness.
Chair, I was given the impression yesterday that the supplementary was going to be delivered to you last night. You may not have received it, or you may have received it, but I know you were dealing with another hearing.
I was not told anything. I think I see my registrar is shaking his head.
So it sounds like it didn't reach even
So
your
it
registrar.
didn't reach,
But
yeah.
can I just check if a spare copy is available? All right, no, I'm afraid no spare copy is immediately available. All right, thank you. So then may I, with your leave, Chair, then take the witness to the main affidavit that you have admitted. If I can just mention that the two supplementary affidavits give additional detail for some of the topics in the first affidavit. I would have preferred, if everything had been before you, to deal with all of that topic by topic.
Yes.
But I may just have to come back to the supplementary affidavits and just fill in the detail then. So I apologize. It's not an ideal logical sequence,
Yes.
but I'm afraid the logistics sometimes get complicated.
Okay, no, that's fine.
Thank you, Chair. And may I, with your leave, lead the witness through some of the uncontroversial aspects
Controversial,
at
yeah.
the beginning.
Yeah.
Thank you. Mr. Teubes, can we go back to your main affidavit, page 6? You mentioned that your current title is General Manager of Combat Systems at DLS, and you refer in your affidavit to your background on page 8. You're a qualified mechanical engineer with a BEng and also a Master's in Business Leadership, an MBL, is that right?
That's correct, Chair.
And you joined Arms Corps in 1989 and moved to Denel when Denel was established in 1992.
That's correct, Chair.
And you worked in different capacities. You set out your various capacities on the rest of this page 8. Correct?
That's correct, Chair.
Right. Did you work throughout this period from 1992 until today at Denel?
That's correct, Chair.
And always in DLS?
Always in DLS. There was a period, Chair, that I worked in the UAE, stationed in the UAE, but still employed by DLS.
Right, thank you. Now, you've referred in paragraph 2.12, page 10, to your involvement in the Hoefyster program, going back as far back as 2004, and you've fulfilled various roles as an employee of DLS on that contract since 2004 until today?
That's correct, Chair.
Right. Now, on page 11, you'll see that paragraph 3 is headed A Brief History of the Hoefyster Contract. That then flows because of the problem with the sequencing of the pages in the photocopying process and the pagination process that I've already raised with the learned chair. Page 11, that ends with 3.2, is followed by page 13, according to the pagination with 3.3. Is that correct?
That's correct, Chair.
Right. And you have set out there a summary of the Hoefyster contract involving Denel and DLS in particular. Is that
That's
right?
correct. That's correct, Chair.
Now, I'd like now to get to the first meaty topic that you deal with in your affidavit, having dealt with this background, and that is Denel's acquisition of an interest in LMT Holdings, and you start that on page 14, and that runs through for some pages. Can you, without going into all the detail in the affidavit, because that's there before the chair, for the learned chair to be able to read in due course, Can you just summarize in a couple of sentences when LMT was acquired, what was acquired, and why?
Chair, just as background, and I touched on it in the Hoefyster section as well. When Hoefyster was initiated as from an RFP perspective from Armscor, there was a requirement to do some tests in South Africa, as well as do some technology transfer to South Africa from the different foreign suppliers. In this case, specifically Patria. Patria contracted LMT locally to be their local engineering partner for the Hoefyster program. So in the pre-contract phase, where a lot of work was done, including the landmine testing, LMT was contracted by Patria to support them. So in this period, a lot of intellectual property for Hoefyster program, specifically on the vehicle, was vested in LMT. So at a certain stage, we got involved with LMT when the RFP was submitted to Armscor. And in that stage, as per my affidavit, and I think we probably go in later in detail, is we got to know of the difficulty, financial difficulty of LMT. And we had to take a decision in terms of protecting the IP that was already created for Hoefyster in LMT, what needs to be done to action that. And this acquisition program was partly then to protect the created IP within LMT on the Hoefyster program.
Thank you. Had LMT, prior to it having a majority share purchased by Denel, had it prior to that been providing work and equipment to Denel?
Chair, yes, although on a very limited basis. There was not a big contracts, so it was more on specialized vehicles, of which the quantities was very low.
And did LMT have capacity to build hulls for the armored vehicles that are relevant for Hoefyster contract?
Chair, very limited.
Right. Now, may we then turn to page 20, and you deal with the first transaction involving VR laser, and that related to the production of 217 armor hulls for the Hoefyster platform components in 2014. Now, if I can just ask you a point of detail before we get into the substance, there's reference to 217, so that's 217 vehicles. There's reference in papers that have come before the chair already in this commission that that there was a variation from 217 down to, I think it was 183 or 84. Is that correct?
That's correct, Chair.
Right. So when you refer to 217, that's the original number that was contemplated, but later it was reduced slightly.
That's correct, Chair.
Right. Now, we've dealt with LMT's capacity and what it did before it was acquired by Denel, or the majority shareholding was. Were you aware of VR laser before this transaction that we're going to deal with here in 2014? Did you have a relation? Did you, as Denel, have a relationship with VR laser?
Chair, we as Denel had the relationship. The majority or the major area of the relationship was with one of our sister business units called MECHEM. It's more in the humanitarian area, and the VR laser was building Caspers for them as one of the main supplies to Denel.
Right. And how do the Caspers compare with the Hoefyster contract vehicles? Was it similar? Was it identical?
It's not. It's similar processes, but it's not identical vehicles, okay. Chair.
All right. Now, you refer in your affidavit, I'm not going to take you again through the detail, but you refer to the point that you didn't have a direct involvement in the RFO or the evaluation process. Is that correct?
That's correct, Chair.
So, and then you refer to in 514, page 21, to a cross-functional team selected by Ms. Malashlela. She was then head of supply chain within DLS. Is that correct?
That's correct, Chair.
And she selected members to sit on the cross-functional team. Were you a member of that cross-functional team?
I was not a member of the cross-functional team, Chair.
Okay, so you didn't take part, or did you, in the evaluation of the proposals received by the bidders in response to RFO?
Chair, I did not take part in the selection process.
Were you part of the executive of Denel at that, of DLS at that stage?
That's correct, Chair.
Right. Now, were you involved in the decision? I know you weren't involved in issuing the RFO or the evaluation of the offers that came in response, but were you involved in the decision at executive level to go out on an RFO process initially?
Chair, just to clarify, the decision to go out on the RFO was not taken on executive level. It was taken within the supply chain environment.
Right. Now, there's been some suggestion by some witnesses who have already given evidence that LMT had the capability of making these hulls, platform hulls for these vehicles, and it was now majority owned by Denel, and it would make sense to keep that in-house. And in fact, the policy was to procure from an in-house division or entity rather than going outside, if that could be done, subject to the price being acceptable, quality, etc. Do you have any comment or view in relation to the fact that LMT was not automatically given this business, but instead the supply chain entity went out on an RFO, allowing competitive prices to be submitted?
Chair, I think to have a view on it, I would like to, there's two variables in it. The one variable is, I think we need to distinguish between a facility or a capacity that can do mass production versus a facility that can do prototype production. So if the question is asked, do LMT have the capability or capacity? The answer is yes for prototyping, for low volume type production, the answer is yes. For high volume production, I don't believe that they had the capability, and if to execute Hoefyster, they probably would have invested a lot of money in their infrastructure to do that. So I think that's important. Maybe just to note that. Sorry, the second question.
No, I think you've covered what I was really trying to get at. But your views that you've just expressed, you were not consulted before the decision was taken by others to go out on an RFO?
No, this is in the majority of the cases, this is done on a program level, but the EXCO cannot just excuse them from this decision. When this decision is then presented, or the outcome of this at EXCO level, then EXCO needs to make a call on the process that was followed, yes.
Now, you then, on pages 21 to 23, set out the detail of what you were able to pick up from the documents of the cross-functional team and their evaluation, correct?
That's correct, Chair.
But you weren't involved personally in that process?
That's correct. As part of the preparation for the commission and the questions that was asked, I did my own research, and this is the information that I could collect on that.
Now, you refer on page 22 to a recommendation made by the cross-functional team, paragraph 5.1.10. You see that?
That's correct, Chair.
Cross-functional team made a submission to the DLS EXCO. Were you part of that EXCO that considered the recommendation?
Chair, yes, I was part of that.
And what was the recommendation for?
The recommendation was for the contracting of VR laser.
Was the decision to be taken by EXCO or anybody else?
The delegation, this was above the delegation of the DLS Exco. So the DL Exco's role in this was a recommendation to the corporate office, because this specific delegation was above DLS.
So Ms. Muller-Schleller and her cross-functional team made a recommendation to Exco. You were required to approve that recommendation before it went higher, but the fact that you approved it was not the final word. Your approval was simply to approve it as a recommendation to head office.
Yeah, Chair, if it's okay, I don't think it's approved. We can only recommend it onwards.
Yes.
So yeah, so there was no approval from our side. Is we had to evaluate it, and then if we were happy and if we supported, then we recommended it for higher approval.
I might just have a moment, Chair. If I can ask you please to turn to page 408.
I've got it, Chair.
Are you familiar with this document that you've referred to in your affidavit?
That is a submission, yes, to the DLS Exco.
And relating specifically to this Hoefyster Hull contract
That's correct, Chair.
and the appointment of VR Laser. Now, it is at page 412, space is made for you to sign as recommending the proposal for the award to VR Laser in your capacity as Chief Operating Officer. Was that your capacity at that stage?
That's correct, Chair.
And who did you report to, Mr. Teubes?
Chair, I reported to Mr. Stefan Burger as the CEO of Denel Land Systems.
So he was CEO, you were COO, correct?
That's correct, Chair.
And there was space provided apart from your name and that of Mr. Knutzer, the Chief Financial Officer, at the foot of the top half, below your name. There's provision for Mr. Burger to endorse the recommendation in his capacity as CEO.
That's correct, Chair.
Did you and he in fact endorse the recommendation?
No, we did not.
And why was that?
Chair, the submission that was made at this stage was made with old information. This prices that was submitted here was still received in 2012. So we believed that the suppliers should get an opportunity to put up fresh submissions. Firstly, secondly, these quotes that they referred to was not valid anymore at that stage, Chair. So it was, from a process perspective, also not the opportune point to take a decision with quotations that was not valid.
So that is a submission on the 25th of April 2014, page 409.
That's correct, Chair.
And you didn't accept the recommendation of the cross-functional team. You required further updates to be provided to the organization.
That is correct.
Right. And were those updates then asked for by DLS of the bidders?
They, according to my knowledge, Chair, they went out then on a formal RFP process to the different bidders, yes.
Right. Now, if I can take you, please, if I might just have a moment. Page 255. Now, 255 contains a series of emails. I'd like you, please, if you would, to go to what appears to be about at least halfway down, an email from you sent on the 25th of April 2014, addressed to Ms. Malashlela and copied to various others. Do you have that?
I've got it, Chair.
Can you just read for the record, your subject refers to an urgent EXCO meeting for the hull supplier. Just read for the record what you say. Hello, Celia.
Hello, Celia. As an input to the meeting, please check the LMT shareholder agreement and if there are any reference made to Hoefyster. I again got an SMS now from Stefan Nel accusing us of contributing the shareholders agreement with regards to us contemplating contracting and other parties on the whole manufacturing.
Now, the Commission has already heard evidence that there were 3 offers submitted to DLS in response to the RFO. One we know was from VR Laser, which was recommended to be accepted by the cross-functional team. There were 2 others, according to the evidence already produced and referred to in your evidence too, that one was LMT and the other was DCD.
That's correct, Chair.
Now, just explain to the Chair about this SMS that you got from Dr. Nel. Who is Dr. Nel and who was he at that time?
Dr. Nel is the CEO of LMT.
Right. And what was his complaint?
His complaint from his perspective is that in the shareholders agreement, there was some exclusivity for the Hoefyster contract allocated to LMT, and he would like us to abide by that specific condition in the shareholders agreement.
So you were asking, as I understand your email, for Ms. Malashlela to check up if Dr. Nell's complaint was valid. In other words, whether the agreement between Denel and LMT in fact gave them an entitlement to the business.
That's correct, Chair.
And did she come back to you and advise you on a response to your query?
Chair, what she did is she consulted with our internal legal executive, Ms. Denise Govender, to get a copy of the shareholder agreement, because we did not have one at DLS, because the shareholding was at corporate level. So all these documents was on that level. Denise did analysis for Ms. Malashlela on this question, and then she gave a response on that. Yeah.
Right. And what did you understand the response to be, to the effect that there was a problem, that you were bound to give the business to LMT or not?
My understanding, Chair, from that response was no, there's no obligation on us. The obligation on us through that agreement was that we will endeavor to assist LMT with business development and order cover, but it was not project specific.
Now, your affidavit from page 23 to 25 refers to the query that was raised, arising from the SMS received from Dr. Nel. Is that correct?
That's correct, Chair.
And we don't need to take you through it, that I believe, in the detail that is helpfully set out there. And then you refer in paragraph 5.120 to an email between yourself, Mr. Knutzer, and Ms. Govender, and you will find that at page 417, I believe. that correct?
I've got it, Chair.
Right.
Mr. Kennedy, you mentioned quite a few page numbers. Did you end up with 417?
It's 417, yes.
Okay.
Does that reflect the correspondence that you had with Ms. Govender and Mr. Knutzer?
Yes.
I think when you have your head like that, can't hear probably
I'm
whatever
sorry,
you
Chair.
say is not captured properly. Yeah.
I'm
Yeah.
sorry, Chair. Thanks for the
I think
guidance.
if you
I'll
do
keep
it
the
that way,
microphone
yeah.
down. I beg your pardon. I'm afraid my eyesight is not good and the lighting is not great. And
Yeah,
my
but
height is a further
yes, no,
complication.
but I was noticing this week, I think your eyesight probably has improved quite a lot since some time back.
Yes,
I
it
think
was.
It used to be quite a challenge.
It's-
No,
it-
but I think you have improved quite a lot.
It has a bit. I've had some surgery. Thank you, Chair.
Yes, yes.
So what was the upshot now that had you resolved the issue that Dr. Nell had raised,
I believe so, Chair.
right? And what happened then with the award of the bid? Did you then proceed to make a decision to award the business, or was there a further step for a further revision of prices?
After this instructed, just for clarity, after this first submission in April, which we did not accept, they went out on an RFP process. There was a process followed, and post that process, the LS Exco made a recommendation, and it was subsequently approved then on corporate level, Chair.
Right. And what was the decision?
The decision was to contract VR Laser, Chair.
Right. Do you know who at corporate level made the decision to approve?
That was approved by the group CEO.
Was that Mr. Saluji at that stage?
That's correct, Chair.
Right. Do you have any knowledge of whether Mr. Saluji had the authority under the delegation then applicable at his level, or whether it required further approval or final approval by the board?
Chair, Mr. Saluji's delegation at that stage was up to 200 million. So any contract within that limit he could approve. And according to me, this contract that he finally approved was within that limit.
Now you then, in your affidavit from page 25, paragraph 5.2, deal with the adjudication of the updated request for proposals. So that preceded the final approval of the award to VR Laser. Is that correct?
That's correct, Chair.
25, 26, 27. And I'd like to stop at a point at page 27, paragraph 5 to 10. And there's a reference to an undertaking being given by Mr. Burger to negotiate with VR Laser Services as the leading bidder to reduce the price they had offered. How did that come about?
Chair, Ms. Celia Maraslela shared with myself and Mr. Burger the outcome of the cross-functional team, their recommendation. And as then in evaluating that, Mr. Burger then made this comment that although VR Laser is the preferred supplier, that he will then still negotiate with them to reduce the price further.
But this was a competitive process involving maybe not a public tender, but an RFO for 3 bidders who were competing against each other, not so?
That's correct, Chair.
Yes. Do you know whether the other bidders were also asked to adjust their prices at the time that Mr. Burger said he would negotiate with VR Laser?
Chair, no, the other bidders didn't get an opportunity.
Yeah. Do you have any view as to whether that was fair or appropriate?
Chair, I think the fact that everything was closed and the recommendation was made in what happened normally within the Denel environment, that there's no changes then to the information on that recommendation up to the point where it is approved. And then post-approval, then we will get a mandate to negotiate with the selected supplier to see if we can reduce the prices. So I do submit that the interaction with a supplier prior to the final approval on the correct level is not within the Denel processes.
I'm sorry, just repeat that final answer. Or just repeat your answer again to that question.
Is that in Denel, in the process of adjudication, up to the point where a final approval is given, it is not within the processes that you can engage with a supplier. Post that approval, what happened in a lot of cases, we will then give a mandate to a negotiating team to say, we would like you to reduce go negotiate and reduce the price with another X%. So there's always this goal of further price reduction post the final approval of that contract or the submission.
Are you saying that because of what you have just said, there was no need for the other suppliers to be given a chance to reduce their prices? Or do I misunderstand you?
No. I think if the principal fact is if one supplier is given an opportunity during the evaluation process, all the other suppliers need to have a similar opportunity.
Yes. Oh.
Which was not in this case.
Okay, all right. Thank you. Mr.
Thank you.
Kennedy?
Mr. Teubes, would this be done at the stage that the decision had already been taken to award the contract to that party, and having decided that, you would then make an effort to get them to reduce their price a bit?
That is correct, Chair. But that happens post the approval for contracting.
And would they be aware when they were approached to negotiate a reduction that they had been approved?
Chair, I would not know.
Yeah. Because if they knew that they were approved, there wouldn't exactly be much inducement on them to negotiate at least substantially downwards.
That's correct, Chair.
Yes. Now, was there an issue in relation to the budget?
Just 1 second, Mr. Kennedy, I'm sorry. When there are negotiations post the adjudication for the reduction of the price by the winning bidder, even if they have not been told that they have won, does that reduction, or does the reduction that is contemplated in that situation, a reduction in the price, a reduction that could go down even more than the prices that had been offered by the other suppliers who lost? Or it could, or it might, or it might not?
Chair, there's no specific guidance on that. So it depends on the competitors, how close they were in terms of pricing compared to the winning bid. But if there's a significant difference, then normally you would not get close to it. We are not talking about huge percentages normally that we can negotiate. Normally it's in the region of 5 to 7%. That we can negotiate down.
Well, it may be that there ought to be no objection in principle to a post-adjudication negotiations for the reduction of the price with the winning bidder. If one approaches the matter on the basis that whether or not that bidder should have one should be judged before that negotiation. If it should not have won, then the fact that the price is negotiated after is irrelevant. It should not have won, and at the point at which the adjudication was made, it had a certain price, and that is the price on which it should have been judged. And if at the time it was judged the winner, it deserved to win, then any negotiations that could happen after between it and the company maybe is really neither here nor there. I'm just thinking aloud. Do you have some comments on that?
Chair, I fully understand your point. In my years in Denel, I've never been in a situation where there was a decision made to have a specific supplier selected out of a evaluation process, and then during the negotiations, that position has changed substantially. I haven't seen that yet, no.
Yeah, it could be that if there is to be negotiations for the reduction of the price before adjudication, that should be afforded to everybody, because at that stage they are still all competing.
Yeah.
But if the actual adjudication has happened and a particular bidder has won and it deserved to win on what was known at that time in terms of its price and so on, then it may be that if the company afterwards says, look, maybe we can just get 1 million or 2 million off, get it reduced. Maybe there should be no problem with that because they have won already. Yeah. So the question should be whether they deserved to win. And if the answer is yes, they did deserve to win, then the rest should be fine. Yeah.
Fully agree, Chair. I think that some of the lessons learned in this is that we go through a process and adjudication, then there's clarification questions from the suppliers, and some of this could influence their answer.
Yes.
And obviously there's processes to be followed.
Yes.
But I think the lesson learned here is after this evaluation process, give everybody an opportunity for a final and best offer before we close. Which we haven't done, but I think that's an area that we can improve on.
Yeah. Mr. Kennedy.
Thank you. Of course, an alternative approach might well be you don't allow anybody to negotiate further. You have one chance as a bidder to submit a bid, and that must then be evaluated.
That's true as well, Chair.
Yes, that's another one to say. Don't say somebody has won if you are still unhappy with something like the price. When you say they've won, certainly something like the price should be settled.
Yes.
Yeah.
Indeed. And would you agree with me, Mr. Teubes, that that at least would have the advantage that it would avoid any corruption or irregularity with information being shared with one bidder to, for example, reduce its price to get an advantage over another bidder which had started off with the lowest price?
I fully agree, Chair. Yes.
Okay. Now, in relation to this particular bid for the 217 hulls, VR Laser, the documents that you provided and also that of other witnesses, have indicated that VR Laser was substantially more expensive than the LMT bid, to the tune of about 100 million. Were you aware of that?
Chair, I was aware of it, yes.
Yeah. And there's also been evidence that the amount that would have had to have been paid to VR Laser under the contract, if it was awarded at its price that was being considered in the final evaluation, would have been way over the budget that was available by way of funds allocated for this product. Were you aware of that?
I was aware of it, yes.
So at executive level, did discuss this when you were considering whether or not to endorse the recommendation of the cross-functional team that despite this big price difference, VR Laser should be recommended to be awarded the contract?
Chair, the discussion was in twofold. The one is the differences between the prices with the different suppliers, but obviously we would like to protect the budget on the Hoefyster program. So the prices was also compared to the budget. So there was a lengthy discussion on the, let's call it the integrity of the prices, especially given the changes of prices on the 2012 versus the 2014 submissions, and we were concerned how is it possible that without substantial change in information we can have such a big price swing in the different areas. And I have to state, as LMT price came down, the other two suppliers also went up, 2014 versus 2012. So it was discussed, but at the end of the day, the EXCO said that they would like to protect the budget of Hoefyster and make sure that the final price is within the budget.
And was that achieved? Was a final price achieved that would bring your organization within the budget level?
If I can recall, the budget was about 960,000 a unit, and the price that we contracted eventually was $1 million.
And that was a substantial reduction on the part of VR Laser.
That is correct, Chair.
Right. If I can take you please to page 606. This is a letter that was sent by VR Laser's Mr. Gianni. You see that at page 613. It is dated the 24th of June 2014, and it's addressed to Ms. Celia Malashlela, and it refers to an updated proposal, updated quotation. Does this represent the revised quotation after Mr. Burger negotiated that with him?
Yes, Mr. Chair.
When Mr. Burger negotiated with him, were you part of those negotiations?
No, Chair.
Are you aware whether he did that on his own or with colleagues present?
I don't know. I don't have any details on it, Mr. Chair, so I cannot give a comment if he was on his own or with colleagues.
All right. Now, if I can take you back to page 29, your affidavit sets out a table from page 29 to 30 is a table. What does that reflect?
Chair, that reflects a summary of the revised proposal that was sent from VR Laser.
Right. And it's apparent from this table, correct me if I'm wrong, that some prices were reduced, but some for different items were kept the same.
That's correct, Chair. On all the small amounts and industrialization and the learning curve areas, that prices was kept the same. The prices that was reduced was on series production prices.
And if we look at page 30, where do we find that?
Chair, that is just above the heading quotation for mine protection only. You will see there's series production units based on the DLS schedule. The initial price was 1.108 million, and they are bringing it down to just over 1 million.
Right. Quite a substantial difference.
That's correct. It's roughly about 10%, Chair.
Yeah. Now you then refer to your recommending that, this is in 5221, that the reduced price be incorporated into a draft submission to EXCO for a final decision by EXCO, correct?
That's correct, Chair.
And then You refer at the top of the next page to a different view being expressed by Ms. Malashlela. Did she convey that to you?
She did, yes, Chair.
And what in essence was the point of disagreement between you and her as to whether or not the revised price could be incorporated into the submission to EXCO?
That is correct, Chair. Her view was exactly as described earlier, is that there was a process followed, and you cannot consider any other inputs post the closure date of the submissions. My view was that, yes, I agree with that, but this specific price is lower from a, let's call it from a program advantage perspective, and I thought that it would give us a better negotiation position as well as a mandate from management to include that. But I have to state, and it's further stated, that I've agreed with her and that submission was not updated.
Was not updated?
No.
Right. Was the matter then referred to EXCO?
Yes, Chair. If I can just correct, the matter of differences between me and Ms. Malashlela wasn't referred. We've agreed on it. So the two of us were happy with it. So the submission was then referred.
Sorry, the submission was?
Referred to the EXCO for further recommendation.
Right. And how did EXCO deal with it?
They recommended it.
Recommended. And was that in terms of the final revised price that we've just been looking at, going down to just over $1 million?
No. It was still the original submission from Ms. Malashlela.
And was there then to be further negotiation thereafter?
They could not make that call until that was approved, Chair, on group level.
And what happened then?
Can I just for clarity, it was then referred to group level.
It was then referred to group level.
Correct.
It was then approved at group level.
That's correct. That's correct.
And was there to be any further attempt at negotiating a reduction after group level approved it?
Yes. Yes, Chair. This revised proposal that was sent, that was not considered, gave us at least an indication that they are willing to reduce their prices. So that was then given as a goal in terms of a contracted price with VR Laser.
Now, what did you understand to be motivating Ms. Malashlela's resistance to include the revised price, even though it gave an advantage, a financial benefit to Denel? What did you understand her purpose to be in resisting your suggestion that the proposal be updated for submission to EXCO?
I don't think there was any sinister, Chair, any sinister views. It was purely, this is a process that was followed, and she would like us to stick to the process as within the policies of the network.
Right, thank you. If I can take you, please, to your affidavit, paragraph 37. You refer to your concluding a covering letter motivating for the conclusion of an MOU with VR Laser to be signed off by Mr. Burger. Did you attend to that?
Yes, Chair.
And did he in fact approve it?
He signed it, and the approval level was on group. So he signed it to be recommended for approval on group level.
Right. Now, may I just ask you to give a comment as to how you felt about the process overall that was being conducted here for the grant of a contract to VR Laser.
Mr. Chair, just for clarity, are we referring to the whole contract or the MOU?
The whole process that led up to the approval of the MOU. Did you feel it was being done correctly? Do you feel it was being done with sufficient time and attention and compliance with procedures?
Firstly, I think there was a rush to get this through, and in hindsight, at that stage, it did not concern me. I didn't have specific concerns of why it is rushed. I think hindsight, I have to say I am concerned with the fact that it was rushed through. I think the fact that it started as a MOU, as an initial process, there's also not a clear processes in Denel to handle MOUs. There is clear processes for approval of single source suppliers, but not MOUs. So I think at that stage, I did not question it. But in hindsight, I would agree that yes, there is a level of uncomfortableness with it.
Chair, at this stage, may I suggest a 5-minute adjournment so that we can attend to the problem that was raised earlier, and that was the missing supplementary affidavit. At this stage, it would be convenient to refer the witness to that. May we ask for just a 5-minute adjournment so that your file, with your leave, may be updated with the addition of that affidavit?
Don't you think we maybe should just make it a T adjournment?
As you please,
so
Chair.
that we don't have to take another time.
Certainly, Chair.
So we might end up with about 10 minutes. But you let me know once you are ready.
Thank you. We will
Okay.
do so.
We adjourn.
All right. Please check in your file
Yes, Mr. Kennedy.
Chair, thank you. May we thank you for the indulgence to get the papers in order. Once again, the apologies for the problem. You have before you, Chair, the main affidavit, which you've already admitted. May we suggest, subject to your guidance, that that be given...
Are you keeping your mask on intentionally, or you forgot to?
No, it's,
Okay.
it's an oversight. Thank you,
All
Chair.
right, okay.
One gets scared when you actually start to get so used to it that it becomes almost like wearing your glasses.
Yeah, well,
But thank you for your guidance.
okay, thank you.
The main affidavit has already been admitted, and what we suggest that be admitted as is then either 417A or 417.1. And then
You now talk about the supplementary.
the one that's already been admitted,
Yeah.
just to distinguish it from the two supplementaries that we're going to deal with
Or
now.
you want us to change W17 to W17.1?
Yes, may I suggest that?
Okay. Well, we can leave it as W17 and make the next one W17.1.
As you please, Chair.
Yeah, so maybe let's do it that way, because on record we have already said this one is W17.
Thank you, Chair. And may we now direct your attention to what has been added to your file, as you gave leave to do during the tea adjournment. You should find at page 850.
850.
Yes, Chair.
Yes.
A first supplementary affidavit, which we would ask once the witness has confirmed its accuracy to be admitted as W17.1.
Yes, I've got it.
And that will run for many pages, with including a number of annexures.
Yes.
And then I mentioned that we've received now a further supplementary affidavit, which I understand has also been added to your bundle, that you will find at page 1078.
Yes, I've got it.
And we will ask that, once it's been confirmed by the witness, be admitted as W17.2.
Yeah.
In fact, may I just correct myself? It's currently not in the form of an affidavit. It's currently in the form of a signed statement.
Okay,
But
that's
Mr.
fine.
Pillay, the attorney assisting Mr. Teubes, has kindly indicated that he will attend to it straight after, and if that can be substituted in affidavit form
Okay,
in
that's
due
fine.
course. May I then just go through the process of referring the witness to these two affidavits or statements, and then just ask him to confirm their contents, and then we'll ask for formal admission.
Okay.
Thank you, Chair. Mr. Teubes, can I ask you please then to refer to page 850?
Yes, I am there.
This is a statement stroke affidavit. Is it correct that you prepared this affidavit, or you finalized this affidavit?
Chair, yes, that's correct.
And that was at the request of investigators of the Commission who'd raised certain issues.
Chair, yes, that's correct.
And then may I take you please to I'm sorry, Chair. Oh, I've got it here. It was concealed by the staple. Page 862. Is that your signature on the 21st of October? That was a week or so ago that you signed this affidavit
Chair, yes, that's correct.
in front of a Commissioner of Oaths. Have you been through this affidavit, and are you satisfied, and can you swear on oath to the learned chair that the contents are true and correct as far as your knowledge goes?
Yes, Chair, that's correct.
Right, thank you. We would then ask formally for leave to have this affidavit of the 21st of October from page 850 admitted in the record as Exhibit W17.1.
The statement stroke affidavit of Mr. Reenen Teubes starting at page 850 is admitted as Exhibit W17.1.
Thank you, Chair. You can just complete this process, Mr. Teubes, by referring you to page 1078.
Yes, Mr. Chair.
That is referred to as supplementary statement, and it runs through to page 1082. Is that correct?
That's correct, Chair.
On that latter page, is that your signature bearing the date of yesterday, the 29th of October?
That's correct, Chair.
It hasn't yet been sworn in front of a Commissioner of Oaths,
That's correct, Chair.
but do you confirm the arrangement that I've made with your attorney, Mr. Pillay, that that will be attended to, and we will be sent the attested version as attested in front of a Commissioner of Oaths?
That's correct, Chair.
Have you been through the contents of this statement?
Yes, I have.
And do you confirm the truth and correctness of the contents as far as your knowledge goes?
That's correct, Chair.
Right, thank you. Chair, we would then ask formally, please leave to have this statement from page 1078 admitted as Exhibit W17.2.
The supplementary statement of Mr. Reenen Teubes, appearing at page 1078, is admitted as Exhibit W17.2.
And Chair, may we ask your formal leave to substitute for these pages the pages of the affidavit once it has been commissioned, and we give you the reassurance that that will be done only on the basis that there will be no change to the content of the statement.
Yes, that is in order.
Thank you, Chair. One final issue on this latest statement, Mr. Teubes. You refer to a number of annexures. You have indicated to me privately that the annexure references in fact refer to annexures by their annexure number that have already been attached to the main affidavit. Is that correct?
That's correct, Chair.
And so on that basis, Chair, we will not attach any further copies because that would simply be a duplication.
Is it apparent from the supplementary statement that the references to the annexures are references to the annexures to his main affidavit? Because that's important. Otherwise, when one reads the supplementary statement, one will think the annexures are missing. So if there
yes,
is,
I understand the point.
if in the text of the supplementary statement it's clear that the annexures being referred to are those attached to his main affidavit, that's fine. But if it's not apparent from it, it may be necessary to find a way of informing whoever reads that the annexures referred to are those in the main affidavit. That might be done.
Yes.
One way of, a formal way of doing it would be maybe a supplementary affidavit that would explain that by him. An informal way would be some indication, but I suspect that it's better to do it formally.
May I make a suggestion in this
Yes.
regard? It's not clear from the statement that they are in fact annexures to the main affidavit, so there is an issue.
Yes.
This is the statement that needs to be converted into an affidavit.
Yes.
May we then take the liberty of when that affidavit is prepared, perhaps where he makes the first reference to an annexure by number, you'll find that at page 1079, para 2.1.5. It's right to the foot of the page. Perhaps what I would suggest, the easy way, if it's satisfactory to you, Chair, is for the affidavit to include an additional sentence to say, the reference to this and all other annexures in this affidavit are references to annexures to my original affidavit.
Yes, no, that would be in order. And when it says original affidavit, I think it might help because that affidavit now has an exhibit number. It might be helpful to say my affidavit deposed to on such and such a date, whichever has been admitted as exhibit so and so. That would be in order. And I guess what we can do, I can grant leave that the replacement affidavit that is going to be put in may include such an additional sentence.
Thank you, Chair.
Because he was going to do, he was still going to go to a commission of oaths for this one.
Correct.
But it's meant to be exactly the same as this. But I'm happy to give leave that such a sentence be included.
Thank you, Chair.
So that Exhibit W17.2 will include that sentence.
Thank you, Chair.
Yeah, okay.
Are you comfortable with that arrangement, Mr. Teubes?
Thank you, Mr. Chair. We will do.
Right. And our team will obviously liaise with your attorney to make sure it's all done in the correct way and done speedily.
Thank you, Mr. Chair.
Thank you very much. Right. Thank you, Chair. May we then turn to the supplementary affidavit received a week or signed a week or so ago at page, that's W17.1, page 850, Mr. Teubes.
Thank you, Mr. Chair.
Now, some of this affidavit overlaps with the affidavit that we've already been through, at least on the Hulls contract. Does this affidavit deal at all with the Hulls contract, the one from 850? You refer to a prepayment to LMT,
Yes.
right? Then you deal at page 860 in paragraph 4 with the Hoefyster Hull contract. That's the one we've dealt with this morning already, correct?
Yes, that's correct, Mr. Chair.
And you deal with some specific questions that were raised, as I understand it, by the investigators. Is that right?
That's correct, Mr. Chair.
Yes. So you expand on your earlier statement regarding the Patria contract, and is there anything you want to add that arises from 4.1?
Yes, Mr. Chair. The Hoefyster Hull contract is addressed in paragraph 4 on page 860.
Yes.
But there's nothing more, Mr. Chair, that I would like to add other than what was already discussed.
Okay, thank you.
Okay.
I'd like, if I may, Chair, to just direct the attention of the witness to 4.2.
Yes.
You refer to efforts from DLS to improve LMT efficiency and quality. Now, you'd referred to some efforts in your main affidavit. As I understand it, you were here giving further detail and documentation just to support what you'd said in the main affidavit. Is that right?
That's correct, Mr. Chair.
And just sum up for us, please, for the Chair, what was being done and why in regard to efforts by DLS to improve LMT's efficiency?
Mr. Chair, over a period pre-ownership and post-ownership of LMT, various contracts from DLS was placed on LMT, a variety of contracts ranging from design work right through to production. Our support on that was a couple of things. From a business perspective, we had a couple of our senior people that interacted on a regular basis with LMT to support them in terms of business management. And in terms of quality, some of these communications that I referred to here was from our quality executive that was helping and assisting LMT with their quality processes. And we have also dispatched some of our quality inspectors on a regular basis to assist them on their production lines.
And was that done before the RFO for the Hulls contract was issued?
That is correct, Chair.
Right. Now, that brings us then to 4.3, which is what informed the move away from LMT. And I just want to take you back to your evidence earlier. You've indicated that there were problems with LMT's performance. They were being addressed in the manner that you've just indicated, attempts to improve that came with the assistance of DLS, correct?
That's correct, Chair.
Right. And you've mentioned elsewhere a prepayment to LMT. Was that also to assist them where they were struggling?
That is correct, Chair.
Right. Now, the problems with the performance of LMT seem to have been an important factor in not giving the whole contract to LMT, but rather to VR Laser, despite the fact that VR Laser was so much more expensive than LMT. Is that correct?
That is correct, Chair.
Can I ask you a hypothetical question? What would have happened if the committee, the cross-functional team that Ms. Malashlela was heading, had come up with a recommendation that, given the huge cost saving that LMT was suggesting by having such a lower price, that it should be recommended to the board or to head office to grant the award of this contract to LMT? What would your attitude have been?
Well, firstly, I think coming back to my earlier statement on the additional price submitted by VR Laser, whatever the outcome of this process was, I believe it would have been an objective process, the Chair, so we would have accepted it. But understanding the challenges that was within LMT, we would have also taken additional measures to support them, to improve efficiency, to improve quality. And I also believe, like I've said earlier in my feedback, there would have been a significant investment needed to increase their capacity from a prototype, low volume type environment to a high serious production. So all of that would have been support from DLS to improve LMT.
Do you have in mind what kind of funds might have been necessary in order to give whatever support LMT should have been given in order to improve its efficiencies?
Unfortunately, no, Chair.
Yeah.
No.
Do you have an idea whether it could possibly be anything close to the difference between VR Laser's price and LMT's price?
Chair, that would be a guess. If I give you
yeah.
any indication.
Okay, you don't have.
I don't have an
Yeah.
idea.
Okay. All right.
But would it, sorry, Chair, would it have been possible, do you think, would it have been not advisable to look into that possibility? Particularly given the fact that LMT was not some stranger or outside third party at arm's length. It was majority owned and controlled by Denel.
Mr. Chair, I think all of these actions should have happened prior to the RFP process on the whole contract. Because if you do these actions post, then it would not be possible to take that into account through your evaluation process. So I think the capability and the capacity that we're talking about, there should have been some indication of how we'll establish that pre the RFP process.
Right. Presumably, I'm sorry, Chair.
Well, your answer reminds me of the question which Mr. Kennedy might still be going to in due course of whether if you had a company such as LMT, which was controlled by Denel, 51%, whether it should be put through any competition with outside companies, or whether what Denel should do or DLS should do is this company can do this job. Maybe we just need to help it here and there when we might need to invest some money and maybe go that route without involving outsiders to compete with your own company. Did you have any views on that?
Mr. Chair, in hindsight, it's easier to have a view on it than in that process. In that process, and this is the report that I referred to here, there were significant delivery issues within LMT. There were significant quality issues on products that they delivered. So I think if that was sorted out, and at least there was some firm basis from where you could do that, I think it would have been a different view, yes.
Yes. Well, because I guess if you don't do that as Denel or as DLS with regard to LMT, then you find yourself in a situation where LMT is competing with the Laser and whoever. These are outside companies. And maybe you are going to say, well, we know our LMT, they won't deliver the kind of quality that we require, and therefore you go for an outsider. But it may well be that if you, from the beginning, said, look, if we spend any money on LMT to improve its efficiencies, it's not just for now, it's for long term, it's an investment in LMT. Therefore, it's worthwhile on the long term.
Yeah.
That would be different. Would you agree?
I think it's a valid point, Chair.
Yes, yes. Yeah. Mr. Kennedy?
Thank you. The Chair has heard evidence about a strategic vision and purpose underlying entities such as LMT, buying a stake in LMT to bring its capacity in-house. You've also referred to this, you touched on this earlier in your evidence. Would that not have been a sensible business decision in the wider interests of the group to try and enhance LMT rather than just refusing it business?
Mr. Chair, yes. Maybe just touching on the strategic intent. Denel land systems don't have any vehicle capability. So what do we do is we've got guns, we build all various guns, and we build turrets. Now, turret is the portion where the gun that fits on top of a vehicle. And we've been doing that for many years. So part of our turnaround strategy was to position ourselves as what we call a level 5 system integrator. Now, a level 5 system integrator, if I can compare that with the civil engineering world, it's a turnkey solution. So you would give the customer the whole package, and that is what Hoefyster is, as an example. So DLS took a decision that we would like to position ourselves, and we got approval for it as a level 5, a systems house. So to do that, we needed vehicle capability, and that part of that was the LMT, bringing them within the family. Just to answer the question from that perspective as well is, I think if it was business as usual, then it would not have been a problem to take that decision and to support it. But unfortunately, in a lot of the emails and a lot of the correspondence, it is clear that at a certain stage there was a total breakdown in relationships between DLS and LMT. So we grew apart, we had different strategic visions. And I think looking back, the top leadership that were responsible for both units should have probably reacted on that and brought everybody back in line. It was not done, and we were allowed to go into different directions, and unfortunately the business relationship suffered because of that. And I think that as a basis, unfortunately, had an impact in, are we willing to invest, yes or no?
So you say the bad that relationship that seems to have developed between LMT and DLS, or the breakdown in communication or the tensions, may have, in a way, contributed to that route not being looked at properly.
Yes, Chair.
Yeah.
Right, thank you, Chair. May I just, to complete this part of the evidence dealing with the Hull contracts, take you back in your affidavit, your main affidavit, to page 33.
What page?
33, 33.
Okay.
Thank you, Mr. Chair.
You refer in paragraph 5.2.31 to permission being requested by DLS to negotiate the price to a maximum of 1,050,000 per vehicle, per hull, to bring it down within the budget that was then in place. Was that approval granted by EXCO?
By group.
By group?
Group, yes.
Right. And then you refer in 5.2.32 to contract negotiations took place, which included the reduction of the price. And you refer to a meeting on the 14th of November 2014, where DLS negotiated mainly for a production price of R1 million per unit for each hull, payment of a prepayment of 12%, etc. And then at the top of the next page, you refer to the people who were invited to attend. That was Mr. Gianni and Mr. van der Merwe of VR Laser Services, and Ms. Malashlela and yourself for DLS.
That's correct, Chair.
Did that meeting in fact take place? You were not simply invited, but you attended?
That's correct, Chair.
Right. And what was the outcome of that?
Chair, there was actually a series of meetings. This was the initial meeting, and I cannot recall exactly how many meetings, but there was a couple of meetings that happened on this specific subject.
Did you persuade VR Laser to reduce its price to exactly R1 million per hull?
They did, but the issue was escalation, the escalation formula, where there was a 3-month difference between the two parties, June to November, 3 to 4 months. So on that specific one, we could not move them. So the position was that we were below the mandate of 1050. So that 3 months difference in escalation is a lot less than that 50,000 difference.
All right, thank you. May we now turn to the next contract that you deal with in your main affidavit, and that is a contract that was awarded in 2015 to VR Laser Services, and that you refer to the Memorandum of Agreement. Is it correct that this related to appointment of VR Laser as a single source supplier of certain components?
That's correct, Chair.
Now, am I correct in understanding these are components in addition to the hull that was dealt with in the 2014 contract?
That's correct, Chair.
Right. Now,
The single supplier concept within the context of Denel, is its essence that when Denel appoints a supplier as a single source supplier, that Denel actually gives away its right, which it otherwise would have, to look for somebody else to give us or provide it with the same services, while that other agreement with that service provider is on. For example, if you talk about a lawyer, attorneys as a company, you can have an attorney whom you have appointed to do certain work for you, but that doesn't prevent you from engaging another attorney to do something else for you, even if it's similar. or you could talk about somebody to provide you with certain products. You might appoint somebody to provide you with certain products, but you might decide that you actually need more and go to somebody else to also provide you with it. You have not given away your right to look for somebody else without being in breach of any agreement with the current supplier.
Yeah.
So is the essence of a single supplier appointment that as Denel, you undertake not to look for some similar services or products from somebody else?
Chair, the answer is yes, but will I be allowed just to expand a little bit on that, if
Yes.
I may? In our single source supplier motivations and selections, we will never opt in that category. Nobody that supplies a normal service that you will find out in the market that there are multiple competitors for, we will never go for a single source. What drives a single source? I think it's important to know we develop as well. So most of the products that we have starts from a development phase. So you will develop a specific product for a specific requirement. And in that, it's not high volume. It's relatively low volume. There's significant investment needed in those components. So you will not have that investment in multiple suppliers. So you will go out and choose a partner single source supplier that will assist you in that development phase as well as the production phase. So our criteria to go out for a single source, and just with a triple PFA, we actually need nowadays to get National Treasury approval for a single source. So single source approval, that has changed over years. Well, partly because of the Denel policies that has also changed to be aligned with National Treasury rules. My understanding of it is that, firstly, is it maybe an OEM that has originally manufactured this, that's got the IP, so you cannot go to somebody else. The second portion, is it critical in terms of manufacturing processes? So manufacturing processes that could impact safety of the system or cost of the system. So all of those factors is taken into account in our recommendation or our motivation rather to National Treasury for that approval. So your principal question is yes, you preclude other people from that, but I think it's not an easy process to get to that point.
And it's not so much out of choice that you exclude other people.
Correct.
It's because of the investments that may be involved in developing this, or maybe because there is intellectual property involved which would force you to use that particular entity anyway.
Correct.
Yes, okay,
Correct.
all right.
Thank you, Chair. Mr. Teubes, your affidavit then goes on to refer to Ms. Malashlela wanting to put this contract out to a competitive tender or RFQ process. If you could look at your page 35, paragraph 614, and you back that up with annexures, which are emails and so forth. Is it correct that she raised that proposal or intention to follow a competitive process?
That's correct, Chair.
Is it correct that you took a different view?
That's correct, Chair.
Was that your own view, or was that one that was dictated or instructed to you by anybody else?
That was a view that was instructed by somebody else to me.
And who was that?
That was Mr. Stefan Burger.
Yeah. What was your own personal view? Did you believe that it could or should go out at least on an RFQ, if not an open tender?
My original view aligned with Mrs. Mashlela's view, but in the discussion with Mr. Burger, the points that he put on the table in terms of the interchangeability of these manufacturing components, as well as the investment needed for the manufacturing processes, after having a debate or a discussion with him, I eventually agreed with his view.
Well, in that event, it probably is not accurate to say it was, have you instructed as such, because I think you were persuaded.
That's true.
Yeah, so
Yes.
it became your own view as well after the debate.
That's correct, Mr. Chair.
Yes.
Yeah.
Okay, all right. But the point you make is that prior to that, your view was more in line with Ms. Lahlela's view.
Correct,
Yeah.
correct. And I think that's backed up with my discussion with Mr. Dreven. And where we had a discussion, he did his motivation, and that motivation was not supplier specific.
Okay.
Right, thank you. Can I ask you what your opinion is now, with the benefit of hindsight? Do you still maintain the view that you came to after being persuaded by Mr. Burger?
I think hindsight, in this case also, with everything that happened around it, I probably would have stick with Celia's position. The issue just is that in this whole process, a lot of things other than technical ability started to play a role. So if the let's call it the political ownership part did not play a role, I think it was correct to go single source and not to go out multiple tender. But the fact that there was other factors starting to play a role, in hindsight, I would have done it differently.
Did the controversy that became apparent in the media about who the true shareholders were of VR Laser and their political connections and their connections with or involvement of the Guptas or Mr. Salim Essa or Mr. Duduzane Zuma, knowing that has generated some controversy, does that influence your view that perhaps it should have been good from the beginning to just follow the competitive process Ms. Malashlela was suggesting, or is it something else?
No, it's as you described.
Right.
If I may, could I add something to that?
Please, yes.
I think the context of decision making on Hoefyster is very important, Chair. When we received this contract in 2007, DLS was almost in the same challenges that Denel is today. So we had significant business challenges, significant cash flow challenges, and then we got the Hoefyster contract. At that stage, with limited resources, limited capacity in the company, and we had to start executing an extremely complex contract. So whatever business decision we were taking was to try and reduce the risk on the program. Now, some of that we were successful in, and some we were not successful in reducing that risk. So any of these decisions, for example, getting a single source to do the fabrication, obviously it must be done from a financial, sound commercial perspective, but a lot of it was to try and drive down risks on the program.
I can understand with respect the logic of having a single source supplier appointed so that you can reduce risk, and there are all sorts of IP technical supervision issues, so that you have one entity that you know is going to, for the period of the contract, be committed to dealing with that, and you can then supervise. What I'd like to turn to now, though, is the question of, before you appoint a single supplier, would it not be appropriate to let other entities compete for the appointment of single source supplier? And Ms. So if I may just complete the question, if I may. I'm sorry, it's a bit long-winded. But Ms. Malashlela has already given evidence that, in her view, from the perspective of supply chain management, that it was important to comply with processes that did allow at least a measure of competitiveness.
Yeah, I agree, Chair, with the principle of this. But I also, at that stage, the argument of we just went through a process to appoint a whole supplier, the essence of what we want to put in in a single source is similar. That also played a role in, rightly or wrongly, but it played a role in this decision. But I do agree in hindsight that it would have been a preferred position to go out on a tender, yeah.
Mr. Mlam, I beg your pardon.
Sorry, Mr. Kennedy. Mr. Teubes, what is it that you may not do if you have appointed A as the single source supplier that you may do if you have appointed them but not as a single source supplier? In a way, I'm going back to the question I asked you earlier on. Are there things that you are prevented from doing just because the appointment that you have made of A is on the basis that A is appointed as a single source supplier as opposed to an ordinary supplier?
Yeah. Chair, from the triple PFA, again, my understanding, I'm not an expert on it, perspective, if you don't have a single source supplier, there's certain criteria or certain processes to be followed with tenders. And so for every requirement you have, you need to go out on an open tender. And then that tender is awarded based on that selection criteria. If you have a single source supplier, you can go on a closed tender to that supplier. And in my mind, that is the difference between the two.
Okay, that's important because I think when Ms. Malahlela gave evidence, this issue of the implications of being appointed as a single source supplier, whether it was different from what is provided for in procurement processes and national treasury regulations or instructions, where you are allowed as an organ of state under the PFMA not to go on open tender. But there, the position, as I understand it, is put as if Mr. Teubes is the sole supplier of that product. If there is nobody else who can provide that kind of product, then you don't have to go to open tender. You can just appoint Mr. Teubes because, and your justification is the only one who provides this kind of product. Now, I've always asked them the questions, the people who have testified about that, I said, I don't understand the logic of that provision, because if you invite, you go the open tender route, Mr. Teubes is going to put in his bid. If he is the only supplier of this product, there's going to be nobody else. And then you'll end up with him anyway. But if you are mistaken in thinking that he's the only one, there will be somebody else. And that somebody else could just happen to be cheaper than him. So you lose nothing by going the open tender route, even if there is only Mr. Teubes who supplies this kind of product. That's in relation to treasury.
Yeah.
Is your understanding that the single supplier arrangement at Denel fits into that arrangement under National Treasury and PFMA provisions? Is it that it's the same thing?
It's the same thing.
Yes.
I have to say, if you look at the procurement policies over the many years, let's say over the last 10 to 12 years in Denel, this issue of single source and single source approval has significantly changed. Although the laws has not changed, I think the application of that within Denel was different. And just an interesting example, roughly in about 2008, 2009, the policy at that stage was that the single source approval was done by the chair of the procurement committee, which was equivalent to Ms. Maleshlela's position. So she could approve it in the Denel policies. Over years, I think our alignment between policy and law became closer.
Okay. Mr. Kennedy.
Thank you, Chair. Mr. Teubes, can you turn to page 44, please? At the foot of page 44, your paragraph 6229 refers to the procurement policy of Denel at head office, which came into effect on the 19th of November 2014. You've helpfully attached the...
I'm sorry, did you say 34?
44.
44. Okay.
You've referred us to the procurement policy as it existed in 2014. You've attached a copy of that policy. Mr. Mlambo, who was then the supply chain group executive at head office, has already given evidence in relation to the same policy. Now, you express an opinion in this paragraph that this appointment of VR Laser as the single source supplier in fact contravened the procurement policy. You say that the award of the contract was in conflict with the procurement policy at Denel SOC Limited. Were you aware of that conflict at the time you were part of the process which recommended VR Laser's appointment?
Mr. Chair, I wasn't aware of the conflict up to the point where we got to this point where it was raised. So during the process of the evaluation and decision making on the MOI, I was not aware of it. But up to the point where we had this EXCO meeting where it was raised, I became aware of it.
Notwithstanding that, the recommendation was then made to appoint VR Laser, despite the fact that you were aware of a conflict. Is that what you're saying?
That's correct, yes.
On what basis could you then make a recommendation that you knew was in conflict with the group's procurement policy?
In the EXCO discussions that we had, the issue was that the procurement policy, we felt that the highest authority, which was the group CEO, could approve deviations from it. And we believe that the approval to enter into an MOA was an approval for a deviation. And that was the basis. So it was not a basis of the one overriding the other. The discussion in the EXCO was that this was approval for a deviation. I know it's worded differently in the minutes, but that was the essence of the discussion.
You refer
Well, I'm just wondering why the group CEO could be said to have approved a deviation in circumstances where there was no request for deviation placed before him.
I take your point, Chair. Yeah,
Yes.
yeah.
Yes. Okay. Mr. Kennedy.
Thank you. Mr. Teubes, if I can refer you to page 46. In fact, let's start, if we may, at 45. In 6233, you refer to the committee taking a decision that the memorandum of agreement that was in place with VR Laser took precedence over the procurement policy. Now, what agreement are you referring to there? Was that the Hull's contract agreement or what?
No, Chair. This was the MOA.
This is the MOA that had already been concluded.
That's correct.
Right. And I just want to pick up with a point that you made earlier, because you said, as I understood it, that part of the reasons that persuaded you to give the single source contract to VR Laser, if I understood you correctly, is that these additional components were additional that would be added on to the hulls. The hulls were to be manufactured by VR Laser in terms of the first contract that had already been awarded to it. So it made sense that you wouldn't have different suppliers supplying different elements. It would make sense to have the same one for both. Is that a fair understanding?
That's correct, Chair.
Yeah. Would you accept, though, this proposition that the first contract entitled them only to manufacture hulls, and that, of course, we know was the subject of a fairly competitive process in that the RFO process was followed, where there were at least three interested parties that were offered that opportunity to compete. VR Laser, LMT, and DCD, not so.
That's correct, Chair.
Did the objective and the legal provisions that the chair has referred to of procurement regulations and so forth, did that not then require that the second process, in fact, go out competitively? In other words, these were not items that you could purchase under the first agreement, because the first agreement just had a narrow scope.
Yeah.
This was in addition to that. And so, although from a business sense it might make sense, business point of view, it might make sense to say, well, if we already appointed them VR Laser in the first contract, why not appoint them again? But wasn't it in fact a requirement of the procurement policy that this too be competitive, just like the first process had been?
Chair, I think it's a valid argument. From our perspective is that we've motivated the MOU to the highest authority within Denel, and that was approved and I know there was objections from Mr. Mlambo on it. I know there was consultations, but at the end of the day, it ended up with the top executives in Denel approving this MOA. So from that perspective, my personal view was all of this was considered, and it was a go-ahead to do it. But do I today understand that from a procurement policy, regulations perspective, it could have been done differently? I agree.
Do you also agree that the top executive, however senior, whether it be the group CEO or the group COO or the board itself, they're also bound legally by what is laid down by Parliament in the PFMA, the Public Finance Management Act, what is laid down in Treasury regulations under the PFMA, and also under the procurement policy of Denel itself?
I fully agree.
Yeah. And was it, I'm not suggesting that one shouldn't look at possible blame that should be attached to the senior executives at a group level, but was it not part of your duty, your and your colleagues' duties within DLS to ensure that if a recommendation was going up to head office for approval, perhaps by the group CEO, that you should not be proposing or recommending a decision which might violate the PFMA or the Treasury regulations or the procurement policy of Denel?
Within the context of Denel is that the Denel procurement policy is derived from all the laws and the regulations. That is done by Denel corporate. So on a division level, we act according to the policy. So we don't have a direct relationship with the PFMA. So the policy in our world is a translation of the PFMA and the application in our world. So to answer you, Chair, is that there was no specific specific comparisons done with relation to the PFMA. The comparisons was done to the policy.
Mr. Kennedy's question has brought me back to an answer you gave earlier on, and I just want us to interrogate that. You said that because this agreement had been taken to the group CEO and he had approved, that somehow meant for you that it was fine. Isn't there a problem with that approach in circumstances where it comes from somebody who would have made a recommendation prior to that issue coming to the group CEO, because you don't want a situation where the group CEO says, I approved this because everyone below me recommended that I approved it, and that I relied on their recommendations. And those under the group CEO say, we actually thought since he approved it, it should be fine. You understand my concern? So,
I do, Chair.
yes, yes. So that to the extent that one may be dealing with somebody who made a recommendation at a level before the matter went to the group CEO, each one of those people who made a recommendation ought to be able to defend, if they defend the approval or their recommendation on its merits, and not because later on somebody senior also approved. You accept that?
I do.
Yes. Okay.
I think, if I may add, Chair, at the point where this was finally approved, I think Mr. Dennis Mlambo's concerns was known. So,
Yes.
so it was not a consensus position within the bigger Denel
Yes.
on this.
Yes.
So I would put it that to say that I don't think the final approval could have been based on a consensus.
Yeah.
That there was consensus. It was
Yes.
known that there was a debate on this.
Yes, yes. Of course, that answer would be fine if you say, look, I stand by the recommendation that I made. I think it was a good decision to recommend. But having said that, I am saying the group CEO was aware of a different view or different views from Mr. Mlambo. He was also supposed to take those into account and decide. He decided in a particular way, and I take it that he weighed up the different views, but still be able to say, as far as my recommendation is concerned, that I stand by it, I can defend it, this is how I defend it. Or obviously you might say, look, at that time I thought it was justified, but now when I've had a chance to look at the facts, look at the situation, or with the benefit of hindsight, I'm not able to defend it, but at that time this is how I saw it. Okay. Mr.
Thank you.
Kennedy.
If I may just pick up, just to complete this line of questioning pursuant to the Chair's questions. Here you had Mr. Mlambo at group executive level for supply chain being against the idea, correct?
Correct, Chair.
And he was the expert, that was his field. You're not an expert in supply chain management,
That's
am I right?
correct. That's correct, Chair.
Your expertise lies elsewhere in engineering and also in business leadership, etc. But Mr. Mlambo's concerns appear to be similar to what your own divisional supply chain head, Ms. Malashlela, was warning you about as well. In fact, the process started where she had said, I believe we should go out to tender or RFQs, and she was overruled within the division, correct?
That's correct, Chair.
And then when the process was then pursued, where the RFO was issued, and where the RFO was not issued, where instead it was decided simply to award it to VR Laser, she still raised concerns, did she not, about procurement irregularities?
I cannot, I think in principle you're correct, Chair, but I cannot remember specific concerns.
Okay.
Yeah.
Can I take you to page 831? She, of course, has given her own evidence, but I respect your evidence now that you can't recall specific concerns. But Ms. Malashlela gave evidence that she was instructed to prepare the memorandum we find at page 831, which was to make the recommendation in relation to the DLS contract as a sole supply contract to VR Laser. And she says, are you familiar with this document? Well, you've actually attached it as an annexure, but were you familiar with it at the time?
I am, yes.
Did you give that instruction to her to issue this, prepare this memorandum?
Can I go back to what the Chair said earlier? I don't think it was an instruction, Chair. I think it was we had a debate. I don't think she was forced to write this memo. In my mind, she wrote this memo after we had a debate, and there was alignment on the idea. So I don't think she was forced, and knowing her is that she will not do anything against her will. So I don't agree with the word force. Yeah.
Can I take
Would
you?
it,
Sorry,
I'm sorry, could it be that she was expected to do it on the basis that it was the majority view, even if she didn't agree with it? Is there room for, would there have been room for her to do it under those circumstances? Not because she is forced in the normal sense, but on the basis that the majority view is different from hers.
Yes, Chair, it's possible.
Yeah.
Just quick context here. At this stage, she was an EXCO member.
Yes.
So she was part of this EXCO meeting that had this discussion.
Yeah.
I would think if she had such strong reservations that it would have been minuted in the EXCO meeting, which it was not. And again, hindsight, is the minutes a perfect reflection of the meeting? I don't know. But I would say if an argument is placed that she was forced to do that, it's not reflected in the minutes. In the minutes it says the EXCO took the following decision, and that minutes was accepted as a true reflection of that meeting.
Yes. I think Mr. Kennedy might or might not take that further. I seem to have the impression that her conduct after, in terms of emails, correspondence, seems to reflect that her view was still different from that of EXCO. But Mr. Kennedy might or might not be able to take that further.
Yes, may I just raise this with the witness, if
Yes.
I may? On this very page, we're at 831. Ms. Malashlela, when she was taken to this in her evidence the other day, directed the Chair's attention to 2 points. In the first paragraph, she referred to the group supply chain executive gave an instruction. The DLS must first explore how DVS will be used in the project on condition that, and then, so that relates to DVS, but then she said to the Chair that she deliberately put in a reference above her signature on the next page, 832. I request permission to implement the EXCO decision in this regard. And it was her diplomatic way of recording that, or hinting that it was EXCO that was making the decision. I take your point that she was part of EXCO, but that she was not happy with the decision. She didn't agree with it. So in other words, she was not saying, I, Ms. Malashlela, am in fact asking or recommending that you give approval, Mr. Mlambo. Any comment on that, or do you stand by your earlier?
Mr. Chair, I stand by my point. Obviously, I've got a lot of respect for Ms. Malashlela, and I don't want to debate her feedback to you.
Yeah.
But I think as an ExCo, if an ExCo has taken a decision, you either abide by that decision or you formally state your objection and it must be minuted.
Okay.
May I now take you to your latest affidavit that has been admitted? Can I take you please to page 1078? This is Exhibit W17.2, Chair. That's the one that you prepared yesterday.
Thank you.
In fact, when I refer to affidavit, in fact, will be an affidavit once you sign it before a commissioner votes. But
100%, thank you.
if I can be forgiven for that terminology that I use, just simply for convenience. Now, why did you prepare this affidavit? Was this at our request or the investigator's request?
No, it was my own initiative, Mr. Chair. In the previous supplementary, a question was asked by the investigators who initiated this MOU process, and I only made a single line answer without giving context to it, because I believed I addressed it in various areas within my statement. So I've only stated that it was Mr. Stefan Burger, but I felt after all I was listening obviously to some of the witnesses here, and I felt that maybe the different areas that I've touched on this, if I can give a chronological order of those events, it will assist the Commission. So this is not new information, it is just repacking the chronological order of events.
Well, thank you for your concern to be comprehensive and detailed to give the learned chair the full facts and the documents. May I just ask specifically in relation to the issue we've just been debating at page 1081, paragraph 7. In fact, sorry, perhaps just to give it the context, the discussion from 1079 deals with the motivation of Martin Dreven for the single source. Is that the same single source contract that we've been discussing up to now?
That's correct, Chair.
And does the same apply to the first draft Group CEO supply chain submission, paragraph 3?
That's correct, Chair.
And then the MOU from Denise Govender?
That's correct, Chair.
And the second draft, paragraph 5 on page 1081?
That's correct, Chair.
And does the same apply to 6, paragraph 6?
That is correct.
Yes. I don't believe, unless you want to highlight anything of particular significance for the chair's attention, I don't believe that it's necessary for us in your oral evidence to go through that, but the evidence will be before the chair for consideration. What I would like to take up with you, though, Mr. Teubes, is your paragraph 7 at the foot of page 1081, and that is Celia Malashlela's concern. You refer to a reply from Celia. In context, it is a reply to a second draft submission. Was that the one that you had amended?
That's correct, Chair.
Yes. And the amendment was for VR Laser to be awarded the contract as a single source supplier without going through a competitive process.
That's correct, Chair.
Right. Now, to look at her, how you've articulated her concern, as she conveyed it to you, 711, Cecilia replied 1031 on the 23rd of March, raising her concerns with regard to, is that WRT, with regard to?
That's correct.
Change submission. She suggested that we have a meeting to discuss. I can't recall if we had the meeting or what the outcome of the meeting was, given that it was after the ExCo meeting. Is that still your position? You can't recall the discussion?
That is correct, Chair.
Ms. Malashlela has given evidence about her discussions with you and Mr. Burger, where she raised repeatedly her concerns, and she has expressed to the chair her concern that she really wasn't taken sufficiently seriously in the advice she was giving as the supply chain expert, that this could not be done. Any comment on that?
I have listened to Ms. Malashela's evidence, and that specific concern that she raised, that she addressed in a letter to Mr. Berger, was only done much later than this specific incident. So that is not a direct link between this meeting and that letter that she's written to Mr. Berger. It was a couple of months later.
Mr. Kennedy, the amendment that you and Mr. Teubes were talking about in regard to paragraph 7.1.1.
Yeah.
Is that the amendment that Ms. Malashela talked about, where she said she had prepared a submission going in a certain direction, but she discovered later that that
Yes.
submission had been amended without her knowledge, as I understood the position,
Yes.
to say something that was quite the opposite? Is that
That
That's
is
what
one of
we
the
are
things that
talking
she
about.
testified about. Perhaps I need to take you, Chair, just to cover that adequately.
yes?
I
Because
may have
it's
skipped through
important.
something in the affidavit of Mr. Teubes. Mr. Teubes, you refer in your affidavit to email correspondence relating to the drafts of the submission, where, as I recall, you used the term, I have updated the submission
Yeah.
to adopt a different angle.
Yes.
May I just find that reference? I'm sorry, I don't have it at my fingertips, Chair, but can I just be given a moment?
Yeah, that's fine.
May I ask, while my learned colleagues are trying to find the reference for us, may I ask, was there interaction between Ms. Malashlela and Mr. Burger at this stage in relation to the preparation of the documents and the procedure being followed, or did she do everything through you?
I don't know. I think the chair, the majority discussions was probably with me, although as what happened during the whole contract, there was also regular interactions between Ms. Malashlela and Mr. Berger. So I don't know.
Did, in one of your affidavits, you've referred to Mr. Berger taking the initiative in relation to the approach for single source supplier. Is that correct?
That's correct, Mr.
I'd like you
Chair.
please to expand on that. In what way did that manifest itself?
If I can refer to my latest supplementary statement that I sent through last night,
Yes.
and if I take you to point 2 there on page 1079,
Yes.
there under the motivation for Mr. Dreven,
Yes.
first paragraph, in the week of 4 to 5 March, I cannot remember the exact date, Mr. Berger had a discussion with me regarding the risk on the Hoefyster program, and specifically the supply of fabricated components and the fact that most other companies like Patria are vertically integrated to include this capacity in the company. He suggested that for DLS to mitigate this risk, a single source agreement must be established with a supplier that has this capacity and capability. I agreed with his reasoning in terms of the inherent risk, And then I had a discussion with Martin Reveen to draw up that motivation. But I think I referred to there on the 216 on the next page. This motivation is a technical risk motivation, or it was technical risk mitigation orientated and not supplier specific.
Right, and then if I can refer you on the same page, the top of page 1079, there's a heading, the individual within DLS who initiated the MOA.
Yes.
Just read out that next paragraph.
That, Mr. Chair, that was the question from the investigators, which I reacted to in my previous supplementary. And my answer on that is, it is my understanding that it was Mr. Stefan Burger in his capacity as DLS, the then DLS CEO, who initiated the process of there to be a single source supplier of hoofhoisted turret, armor, steel fabrication and components.
Right, thank you. I'm referred, Chair, thank you, I apologize for the delay. My attention is drawn to page 679. You do refer to it in your affidavit, and I just can't find that at the moment, but yes, thank you, Mr. Beer. 679 is a series of two emails. The one that at the top is from yourself to Ms. Malashlela, is that right?
That's correct, Chair.
And then that was a response to hers at the foot of the page, is that right?
That's correct, Chair.
And further down the page, 12th of March 2015. And she said, "Hi Reenen, please find the attached document as requested." Now she gave evidence the other day before the Chair that she had prepared a submission to deal with the proposed transaction. She dealt with it in a particular way, but you then wrote back to her to say, as you do in the top email, "I've changed the angle that we ask for approval from Riaz. Please see attached submission, any inputs." Now, what informed that?
That was informed by a, if you just look again at the statement of last night, is that we had the first draft as per the email of the 12th of March. Then post that, I received an email from Ms. Denise Governor, our legal exec in Denel, attaching a MOU for this work and specifying VR laser. I had then on her reference, she referred me to Stefan, and we had a discussion and a debate on that, and it was post this debate that I have updated that submission.
Now, can I take you back, please, to page 832, which is the one we looked at earlier, where she refers to a request for permission to implement the EXCO decision, in which she had been a minority. And you mentioned earlier that Mr. Mlambo had taken a different view. We know what his position is at group level. He's basically the top within the group. He was the absolute ultimate authority within the group relating to supply chain and procurement, correct?
That's correct, yeah.
And were you aware that his approval was required for this type of transaction?
I don't agree with his approval. If you look at the policy, it says he needs to be consulted.
Yes, he gave evidence about a particular reason why he should have been consulted.
Yeah.
But leave it at that. the Chair will assess the evidence, obviously in due course. But I'm interested in the handwritten portion that Mr. Mlambo has said he inserted. Do you see the typed portion above the handwritten portion says approval? The intention was to get him to sign to give his approval.
Yeah.
And he didn't sign that. Instead, he wrote in the reason why he was not approving. He said, NB, DVS and LMT must submit proof that they cannot meet the requirements prior to the contract being awarded to VR Laser. Now, you've already dealt with LMT and its limited capacity and its limited track record, as well as problems that will be experienced with that. I don't believe we need to traverse that again. But just deal briefly, if you would, with DVS. He's suggesting that DVS as an in-house division of Denel should provide proof that it cannot do this type of production before he would be happy.
Yeah. If I just, Chair, before I answer that, if I can just give context between this letter versus the approval process for the MOU. This letter that on which Dennis Malambo made a comment is about 6 months after the MOU process. So this specific letter does not reflect on the approval process or input to the approval process of the MOU. It reflects to a position where we wanted to go out, or there was a discussion to go out on either a tender or not a tender on this, the T5 program, which is another product. And the EXCO discussed that, and that's where the whole decision that you referred to earlier, Chair, in terms of policy versus approval levels came into debate. So the decision that we requested here from Mr. Malambo was specifically on a T5 product. You either go out on tender or, in this case, follow the MOU process. So that was the reference in this letter.
Yes. But Mr. Mlambo was concerned with a number of breaches of policy. In fact, the one he's identifying here specifically relates to the in-house capability. In fact, that, as I recall, was his evidence that that required his actual approval before work that could potentially be done in-house was outsourced to somebody outside the group.
That's correct. If there was the in-house capability, then that was subject to approval.
Yes. So were you aware at the time that he had issued this note, firstly showing that he didn't approve it, and secondly giving his reason then? He had other reasons that he raised in his evidence later.
Yeah.
But this specific one, were you aware that this was the outcome of the process in which his approval had been sought but refused?
Yes, I was aware of it.
And did that not ring some alarm bells to you as a senior member of the DLS management, as its COO at the time, that we can't do this without satisfying Mr. Mlambo in terms of his authority and in terms of the prescripts of Denel policy for procurement, that we must satisfy him that both DVS and LMT don't have the capacity?
I agree with the principle that my thoughts at that stage was I got this letter and it was approved by the group CEO. And I would have, and my understanding was that he has taken in Mr. Mulambo's concerns, and then he approved it. So I agree with you again in hindsight that we should have considered it differently. But at that stage, we accepted the group CEO approval of this position.
You know, one of the matters, Mr. Teubes, that I look at from time to time when I hear evidence of how certain things happened in various SOEs during these years that we're talking about in the context of state capture and corruption is where it's clear that the wrong thing was done and not the right thing. I try to look at why is it that maybe so many people who saw this or read the documentation, who had what was being done or what they were being asked to agree to or approve, why is it that not enough people said, but there's something wrong with this? You see? So when then one looks at this issue here, and one hears the argument from Mr. Mlambo that it didn't make sense to him for Denel to want to, so to speak, outsource business when they've got internal Denel entities that have got the capabilities, can do the job. So, and then you see the group CEO having said approved there. Well, when Mr. Mlambo was giving evidence, I said, was this approved, meaning he approved your comments, or was he giving the approval that you were not giving? He said, no. I think he said the group CEO was giving the approval that he was not giving. He was overriding him. So I asked myself the question, but one, what did this group CEO say about the arguments, the merits of the arguments raised by Mr. Mlambo? What did the other people, other than the group CEO, say about the merits of the arguments by Mr. Mlambo? Because one would expect that if there is no sound answer to his arguments, other people who didn't think anybody had given a proper explanation should say, but hang on, we don't understand why you are going ahead, because we think Mr. Mlambo's point is valid, you know. And then maybe if there are enough people who say that, maybe the group CEO is going to think twice before he approves. But if they all adopt the attitude, look, let's leave it to this group CEO. If he approves, he approves.
Yeah.
Then wrong things happen. You understand where my concern is?
Fully understood, Chair. I just have to point out that between me and Ms. Malashela, we did have meetings with Mr. Dennis Mlambo on this issue.
Yes.
And we had discussions with him. So it was not purely a situation, submit this motivation and get either approval or rejection back from corporate. So we did engage with him. There is email communication, post-meetings we had with him on this. But that does not disregard your position and your arguments on it. I just wanted to add that it wasn't purely a blind process.
Yes,
there was interaction.
Yes. But as you sit there and you look at his arguments, what is your reaction as to what should have happened about his arguments? Do you regard them as sound and as there not having anybody who came up with sounder, better, stronger arguments?
Chair, as per the email communication post our meetings, I differed with him, with his arguments.
Yes.
I did not agree with his perception of the capabilities in the different companies.
Yes.
I honestly believe that he did not have the same depth of knowledge on those capabilities that I had.
Yes.
So it's from that perspective I differed with him, and it is known in my emails that I differed with him.
But did you put those arguments to him to say, you say we have got those capabilities within Denel, but you are mistaken on that because of A, B, C, D. We don't have those capabilities, or those capabilities are just not, the ones we have are not adequate for this purpose. Did you get a chance? Did you put that to him?
Chair, I believe in the meetings that I referred to in my emails, I did In retrospect, I should have probably put it in writing as well, which I did not. But
Yes.
I had joint meetings with him and Ms. Malashlela, yeah.
Yes. Okay, all right. Mr. Kennedy.
Thank you. Chair, may I then may I just raise the issue of how much time we still need to run with this?
How much time do you
I-
think you need?
I hope about 20 minutes, Chair.
Okay,
know
let's
you
let's
have
try
other
and finish.
demands, but
Yeah, let's try and finish.
if we
within-
can try and
yeah.
finish, thank you.
Okay.
May I ask you please now to turn right to the end of the bundle, page 862, in fact 861. This is part of the supplementary statement that you prepared yesterday. Sorry, it's the first supplementary affidavit. Do you have it? Not yet, sorry.
I have it, thank you, Chair.
At the foot of the page, 5.4, MOA date versus the acquisition date of Denel Vehicle Systems. Why was DVS not considered? Now, as I understand the earlier part of your affidavit, this is one of the questions that were put to you by the investigators of the Commission for you to answer.
Yes.
That's right.
Correct, that's correct, Chair.
And your explanation at the top of the next page, according to my knowledge, VR laser and DVS processes were two parallel processes. DVS did not have a hull manufacturing capability at the time it was acquired by Denel, and Patria was hesitant to support DVS involvement at the time due to perceived competition on the RG41 vehicle from DVS, which latter issue was subsequently resolved. May I just focus for a moment on the DVS entity? Of course, we've seen Mr. Mlambo was not saying necessarily that DVS had capacity, but at least if it didn't have capacity, it must provide proof that it doesn't have capacity. Was the Patria issue about confidentiality or perceived competition rather in relation to its vehicle? You say that was resolved. Was that resolved before the award of the contract to VR Laser?
No, Chair. That was resolved quite later, and the reason why that the strategy has changed, and including DVS, to be the assembly house for the vehicle. So we had to get approval from Patria in line with their licensing agreement, so that DVS can be contracted for the assembly. So the issue wasn't resolved on the manufacturing. The issue was resolved on the assembly portion of the contract.
Right. Thank you. And then I'd like to just tie up one last loose end in relation to this contract. Can I now ask you please to turn near the front of the bundle to page 35?
Is that 835?
35.
I've got it, Mr. Chair.
Now, this was the passage that I was unable to put my finger on earlier, the changing of the angle. We've seen that the email where you used that terminology a bit earlier. Do you remember? We looked at that.
That's correct.
But what is useful here is to see the reason why you changed the angle according to your affidavit. Foot of page 35, 615. I responded to the email, that's Ms. Malashlela's email, on 20th of March 2015, advising that I'd changed the angle of the draft submission and requested her input on the same. In the revised draft submission, I added to the background and motivation and removed the supply chain notes heading that had been included recommending that the single source supplier be chosen through a competitive bidding process, and also recommended that VR Laser be appointed as the said supplier. Her evidence the other day suggested that she was effectively instructed. You said that you believe that she bought into the idea and was persuaded. You stand by that evidence?
No, Chair, this is two different subjects.
I beg your pardon.
Yeah.
Please
So on this, the letter that we previously discussed was on a T5 program about 6 months later than the MOA.
I see.
Yeah, so this MOA process here was the first draft and the second draft on the submission that is discussed here.
Okay, thank you for clarifying that. Now, may we turn now to a couple of other aspects that are raised in your various affidavits or statements. Turn now, please, to page 48. You refer to, in paragraph 8,
I've got it. Thank you, Mr. Chair.
you refer to negotiations with LMT following the award of the Hoefyster contract to VR Laser. Just summarize what this was about.
Mr. Chair, when we got approval to contract the whole contract to VR Laser, there was a condition in the approval to say, is it possible to find an alternative contracting model to include LMT or not? So that through that approval, it gave me the mandate to engage with Dr. Denel to see can we involve them in this process or not. And with that process, I've developed the two options, option A and option B. That was discussed in with Dr. Denel at length.
And then if you can turn, please, to page 46. This deals with the appointment of VR Laser by DLS in 2016. Now, we've already dealt with the Hull contract that was awarded in 2014, the single source supplier contract that was awarded in 2015, correct?
That's correct, Chair.
Am I correct in understanding you're dealing here with a separate transaction that followed that?
That's correct, Chair.
And that relates to different items than those covered by the first two contracts?
That's correct, also for a different program.
And for a different program, right? Not for Hoefyster?
No, this is for the Malaysian program, Chair.
Right. Now, I appreciate that you were dealing with this at the request of investigators to deal with specific issues, but can you just sum up your points in relation to this particular contract? What significance is there that you would like to draw to the attention of the Chair?
Chair, off the cuff, there's nothing else that I would like to add here. My apologies. But no, I don't think there's something that I would like to add additional to these points.
Okay.
But thank you, Mr. Teubes. There is one aspect that I would like to draw to your attention just to explain, and that's at page 47, paragraph 7.8. Sorry, 7.7. On 22 March 2016, Ms. Malashlela had at the EXCO meeting of DLS raised the concern once more about the apparent over-reliance by DLS on the memorandum of agreement it had concluded with VR Laser, where this agreement was in conflict with the supply chain policy of Denel. Do you recall her raising those concerns in 2016?
Mr. Chair, yes, and in this case, it was also minuted on the EXCO meeting.
Right. So this is and when you refer here to the apparent over-reliance, according to Ms. Malashlela, by DLS on the memorandum of agreement, would that be the first agreement from 2014 for the hulls, the second agreement in 2015 for the single source supply of additional items, or what?
Mr. Chair, it is the second agreement, the MOA agreement with VR Laser.
Yes. And so she was alerting you there to the fact that that second agreement was, in her view, in conflict with the supply chain policy?
That's correct.
Did you discuss it with her? Did you indicate a contrary view to her, or don't you recall?
Mr. Chair, the only discussion was at this EXCO meeting, and as I cannot remember the detailed discussions on the EXCO meeting, but I've reflected the comments that was minuted by Mr. Berger in this EXCO meeting.
Right. And then Mr. Burger's comment, a comment from him is referred to in your paragraph 7.8. You say Mr. Burger, in his capacity as the CEO of DLS, advised that the memorandum of agreement was signed by the Group Chief Executive Officer of Denel Soc Limited and should therefore supersede the supply chain policy of Denel in instances where the two documents were in conflict.
That is exactly how it was minuted in the EXCO meeting, yes.
Yeah.
Did that make sense to you? Do you understand why that should be the case? Because when Ms. Malahlela or whoever gave evidence about it, it sounded strange to me.
Yeah.
That you can have an agreement, you can say an agreement that is in conflict or concluded in breach of the company's policy is fine because it's signed by the group CEO, because one expects that agreements must be in line with the policy.
Yeah.
Did this point
Sorry.
make sense to you when you heard about it or when you heard Mr. Baker say this?
Yeah, Mr. Chair, I was in that EXCO meeting, so
You were not,
yeah, so I was part of it. I have to say I cannot remember exactly what my thoughts was on it. In retrospect, in reading it now, I've got your same concerns.
Yes.
But I cannot recall a specific thoughts on it during that meeting.
Yes. Yeah, it's like, well, if it's signed by somebody higher up, even if it's against the law, it's fine.
Yes.
Yeah, okay, all right.
Noted, Chair. Yeah.
Yes.
In fact, in that vein, may I take you back to a comment that you made earlier, that with the benefit of hindsight, you've realized, particularly in relation to the media controversy and the public interest in the link between VR Laser and the Gupta family and their network, including Mr. Salim Issa, you realize that perhaps things could and should have been done differently. Can I just put a proposition to you, Mr. Teubes, for your comment, if you wish to make a comment? I want to suggest to you that while I accept fully that you're an engineer by background and not a lawyer, doesn't this illustrate that one has to ensure compliance with procurement policies upfront? Because you don't know when you're sitting in a position of Mr. Teubes or Ms. Malahlela or whoever upfront exactly who may or may not be behind particular tenderers and so forth. And you learn the hard way later in an organization like Denel that there are all sorts of things that are coming out of the woodwork. And that's precisely why the process has to be fair and lawful and competitive from the beginning, so that the process doesn't get mired in controversy later when it emerges that a single source supplier has been allocated, contract has been allocated to a company whose shareholders are now causing embarrassment to Denel, and where procurement policies haven't been followed.
Mr. Chair, I fully agree with that. I think that's the hard lesson learned out of this process. I think we've also learned the lesson in this process: be more critical of what's happening and not just accept. And I think if you look at one of the Denel values that has changed now, it's courage, and the courage is to question. And then I think we went through a period where we probably did not question enough. And I think I fully agree with the statement, yes.
And may I ask, to what extent was your feeling of comfort at that stage that is now changed to discomfort? To what extent were you influenced, although you were senior within DLS, to what extent were you influenced by the fact that Mr. Burger was senior to you and was giving you a measure of reassurance, and so too, you've mentioned earlier to the chair, it was subject to the group CEO, Mr. Saluji, giving his approval, and that was given. Did that give you comfort?
Mr. Chair, at that stage, my focus was on the technical performance and the technical risk and crises we had on Hoefyster. So maybe I did not spend enough time in applying my mind around the, let's call it the political ownership environment. So to answer the question, was I comfortable or not, I think as time progressed and with all the media hype around the owners, the level of uncomfort rose. But I cannot give you an exact point where I said to a point, this is unacceptable. But that level of uncomfort rose over time.
Thank you very much, Mr. Teubes. We have no further questions as the legal team for this witness. Thank you.
Thank you very much, Mr. Teubes, for coming to assist the Commission. We appreciate it very much. If we need you to come back, we'll ask you to come back. But for now, you are excused.
Thank you very much, Mr. Chair.
Thank you. Mr. Kennedy?
Thank you, Chair. Chair, we have no further witnesses arranged for today.
Yeah.
We have been allocated further time, not next week, but the following week, starting on the 9th of November,
Yes.
where we have a number of witnesses lined up. We will include Mr. Mancha, and as well as Mr. Nsepe. The legal team will be consulting with him. He wasn't
Yes.
available until now.
Okay.
We will be consulting with him this afternoon.
Okay.
So we would ask for the proceedings of today to then be adjourned,
Yes.
and the Denel stream evidence then to be postponed to resume on the 9th of November.
Yes, no, that's fine. We are going to adjourn for the day. Next week, the Commission will hear evidence by Ms. Kwinana, who used to be a member of the SAA board, as well as evidence from Ms. Dudumieni, who was chairperson of the SAA board for a certain period. So for today, we are going to adjourn at this stage. We adjourn.